if the insurance company feels that they don't have enough money in reserve to pay claims based on the statistics that they do, they apply to the New York State Insurance Department to see if they will let them raise rates. And they do let them raise rates because they want people who've paid for this.
Welcome to the Mortgages Made Easy podcast. I am honored, and I don't use that word lightly, to be joined today by Ronald Fatula. Ron is been in the trust and estates business, a trust and estate attorney for over 40 years, and he's now currently with the firm of Meltzer Lippy. But one of the things you told me that I remember is that someone calculated how much you saved people over the generations, how much you saved them in estate tax. You want to share that number?
Yeah, I was shocked myself. He said, so based on the number of clients you had and the amount, an average amount you save per client, the aggregate amount, the total amount is over 4 billion. It was about $4.7 billion that my firm has helped people save, you know, over the last 40 years of me being in business. So I'm very proud of that.
That's amazing.
Yeah.
And it goes to talk about the fact that you're not a Johnny come lately. You're one of the experts in the industry, and I've known your name for at least 10 years. I'm delighted to get into this with you. Let's start at the top. So let's imagine, hell, I just got off the phone with a young man who's about 30 years old, and he's about to buy his first home. He's married, he has 2 kids, and he probably thinks that estate planning is the furthest thing from what he needs because he's a young man. But what does he need? What does a first-time home buyer need to protect themselves?
Yeah, very good question. So when you're younger and you're just starting out, you just want the basics. So you want to have, at a minimum, a last will and testament document which sets forth where your assets go when you pass away. But that will, that last will and testament, is also a forum to name, for example, if you have young children, a guardian in case something happens to you. Now, I've been practicing for over 40 years, and we've seen everything. A client that I spoke to this morning, and I've seen it twice already, but this is the third one, he won the lottery. So what are the odds of winning the lottery? He won the lottery. What are the odds of something happening to an individual where they pass away at a young age? Well, obviously much lower than if you're in your 50s, 60s, 70s, 80s, etc. But it does happen. And you do want to have a will. And let me tell you, especially if you're younger and you pass away and you don't have a will, New York State actually, in essence, writes a will for you. New York State has a section in our state's powers and trust law, and most states do, that sets forth where your assets go if you don't have a will or a trust. And, let me just go through this because it's very important. First, it goes to a spouse if there are no children, all to the spouse. If no spouse and their children or a child, all to the child. But if there's a spouse and children or a child, it's 50,000 to the spouse and then split equally. If I were 30 years old or 35 years old and the surviving spouse and half of his money or her money went to an infant child, I would be furious. How could that possibly be? How could she do that to me? People need to plan, and that's just, having a will is just simply the very tip of the iceberg.
Right, so you start with a will. What other documents should that young man with the 2 children and the wife, what else should we be planning for?
Right. So definitely should have a healthcare proxy. In
And
other,
everyone should have a health care.
everyone should have a healthcare proxy. You could be 10 years old, you could be 100 years old, but things happen to people, and if God forbid you cannot make your own healthcare decisions, you appoint somebody else who can. There's a phone number on the proxy. How does a hospital know, that you have a proxy? Well, you tell them, but if you can't tell them because you're unconscious, what I tell my female clients, keep a copy of the proxy in your pocketbook. Male clients, fold it up, put it in your wallet. So you always have it. It's always on you. It's very important because if something happens, and things do happen to everyone, and no one is immune from things happening to them. We know that. We all know that. So just in case, it's like an insurance policy. Make sure that you have that healthcare proxy so somebody else that you cherry pick and hand pick and who knows what your healthcare wishes are can make those decisions for you when you can't make them.
And my kids are all grown up, but I remember when we drafted our will, we spent a lot of time focusing on two issues. One was who would be the custodians for our children, and
Exactly.
one would be who would manage the estate until my kids hit majority. They're now all in their, well, the youngest one is turning 30. So
Mhm. Mhm.
yeah.
Yeah.
So
Oh,
you need you need a will, you need a healthcare
a
proxy.
will, and just as you mentioned, in every will we do, there hasn't been one that I've ever done that did not have a minor's provision in it. So if you do have young children and something happens to you, it doesn't go to the state, and it doesn't go to minor children, they're not going to run to the toy store with this. It's going to stay in a trust. In every will we've done, there's a minor's trust within that will. Sometimes client would say, I wanted to go to my children at age 18 or 21. Most people say, that's too young. They might get half of it at 25 and half at 30, or maybe a third at 21, a third at 25, a third at 30. You know, they won't get this until they're more mature. But yes,
Mhm,
in every will, we do have that.
mhm.
Uh,
Right.
yes.
So now, I imagine with the $4 billion in savings that you've generated, a lot of that is about getting ducks in a row.
Mm,
So you said that Congress is up in the air about or actually in our previous conversation, you were telling me that Congress is up in the air about the estate provisions. Um, for the average person, even the $6 million number that is the reversion number, that's a lot of money. But for
yes.
your
Yeah.
but for your wealthier clients, what should they be thinking about?
Oh my God. Even if they're young and they have money, that's especially when they need to do planning. We don't we don't want all of their assets to just grow in their estate. We can actually transfer those assets into different types of trusts, get discounts. So we reduce the estate tax and we try to make sure that there's what's called an estate freeze. We want those assets to grow, of course, for our family, but we want them to grow outside of the taxable estates of our client and the spouse. So it might be the next generation. We might even skip a generation as well. So we try, depending on the net worth of our clients, but usually they want to make sure that their family is well, their immediate family, their children, and then they could talk about even doing some sort of dynasty trust to make sure that their descendants also can share in the wealth.
Yeah, that makes a lot of sense.
Yeah.
Um, so let's go back to our first time home buyer.
Mhm.
And now that young person buying a home probably doesn't need to put their home in a trust, right?
Mhm.
Because that would make things awkward. But
Mhm.
now think about somebody who's in their 60s, 70s, or 80s. Now what do you do?
Definitely, we think about a living trust for sure, and for many different reasons. The basic reasons are number one, yes, you avoid probate. There are other ways to avoid probate, but as you age, there's a much greater chance that you're going to need long-term care. So
Right.
the statistics show, and I was shocked, but the statistics show that there's a 70% chance at age 65, because you said 60s, 70s. At age 65, the stats show that there's a 70% chance the individual will need long-term care in the future. That's
Mhm.
high. That's
Right.
high. I know when I go to Atlantic City and I play blackjack and 51% for the house, 49% for me, I lose most of the time. But when you're facing a 70% chance of needing long-term care and you're not going to plan for it, it's insane. So we do planning for these individuals. We protect assets. The home typically will go into a living trust, not a trust within a will. That's called a testamentary trust. It would be a living trust that's signed now while the individual is living. The trust is good right now, and we transfer the home, the title on the home, to the name of the trustee of the trust right now. So it's out for long-term care purposes, and more specifically, it's out for Medicaid purposes
Right.
because
You want
in
to explain that? Because I bet a lot of people don't understand that.
Absolutely. So, good question, David. So, when you think about paying for long-term care, what do you think about? You think about opening up your checkbook and writing checks. So, private pay is one way to do it. But think about it. The average cost of 1 month in a nursing home in the New York City metropolitan area is about 20,000 a month. It's a lot of money. So we're talking about $250,000 a year without planning. If you need home care, we've seen clients pay even, that amount, usually lower, but it could also add up to quite a bit. If you're thinking about 24-hour care with 12-hour shifts, it's quite expensive. So most individuals simply cannot afford to pay, privately. How else could they pay? If they're lucky enough and can afford it, and they're healthy enough to get it, it's long-term care insurance. It's a great thing. It's a wonderful way to pay for long-term care. But I would say 95+% of the clients that I see have not purchased long-term care insurance. And many of my clients purchased it and had to let the policy lapse because insurance companies kept raising the rates on the policies. I am seeing a client tomorrow, Friday morning, and this is an exact number. The insurance company raised his rate for just him and his wife, sorry, just him and his wife, to $85,000 for 1 year of long-term care insurance. It is a policy, it's a lifetime policy. There's no term limit. It's a great policy, but it sure is a heck of a lot of
Not
money.
everyone can afford $85,000 a year.
And that's unusual. It's unusually high, very unusually high. But that's the client that's coming in tomorrow morning. But
Mm.
long-term care insurance is another way to do it. I bought the insurance. I have it. I'm not happy about the rate increases that I have to pay. But if the insurance company feels that they don't have enough money in reserve to pay claims based on the statistics that they do. They apply to the New York State Insurance Department to see if they will let them raise rates. And they do let them raise rates because they want people who've paid for this to be able to use the insurance company. So I've had to pay increases a couple of times myself. But thank God I could afford it with no problem. And I feel, grateful that I could do it, but many of my clients cannot. So the only other way to pay for long-term care is through the Medicaid program. And, How I got into doing elder law also, not just estate planning, is in the 80s. I actually saw about 5 clients within a couple of months. I saw the spouse, and the spouse said something like this: I had $1 million in my name. I spent all of my money on my husband's care, and I'm down to almost nothing. How am I going to pay for my husband's nursing home in the future? So I had 5 clients within a couple of months with the same story. And every time I was almost furious. I was infuriated because I know that I could have protected the asset so that I wouldn't be facing an impoverished spouse who had money to live her life. Don't forget, in the 80s, having $1 million was a lot of money, not like $1 million today. So I had 5 of those clients, and my mantra at the time is, I have to get into this business, this law business, and protect spouses as they age, because I just don't want to see another impoverished spouse. When I see a spouse, I'm giving you an example, but I've seen them because it's a vivid picture in my brain of a 90-year-old, a 95-year-old. Her hands are shaking. She's emotionally distraught. She's a wreck. And now adding the financial burden to the story is heartbreaking. And I made it my mantra, a mission to have no more impoverished spouses. And that's the sort of planning that I do amongst others. But I feel especially proud of what I do when I do that, because at least I'm helping this individual, the surviving spouses, or shouldn't just say surviving, the spouses that are also living with a spouse that has a serious disease, um, live a good life that he or she deserves. They
Right,
earn that money.
right.
Yeah.
So you're talking about trust, and for Medicaid purposes,
Mhm.
what kind of a trust do you have to set up? Is it revocable? Is it irrevocable? And maybe start by explaining the terms.
Sure, sure. Many people call it a MAPT, MAPT. It's not an easy acronym to say, but it's a Medicaid Asset Protection Trust. That's the common terminology now throughout the United States. So it's a MAPT, Medicaid Asset Protection Trust. It happens to be irrevocable. So let's say you're dealing with mom and dad, and they have a home. It's not a first time purchase, but let's say they bought a home 40 years ago, and they might be talking to me and saying, oh, I'm not going to put it into a trust or a Medicaid trust. Uh, I think I'm healthy. I want to take a chance. Bad idea. You want to buy fire insurance so that your house won't burn down, but this is insurance. Put the home in a trust. And yes, you avoid probate. That's what a lot of my clients talk about, but you preserve the home for long-term care. And that's the big, big issue here. And also Medicaid recovery you preserve. But not only that, when the home is in the,
Wait, just
oh,
slow down for a minute, because I know
oh,
what Medicaid
absolutely.
recovery is, but many people won't. What is Medicaid recovery?
Oh, absolutely. So let's say you go on Medicaid. Medicaid is paid for the nursing home or home care at home, and then you die. If you have assets that will be probated, could be a home, it could be a brokerage account, it could be a bank account. If you have probatable assets, then Medicaid can and will recover against your assets and want to recover all of the money that they spent on you.
Well, let's be clear. If you were talking about a nursing home costing, what did you say,
About 250,000 a year.
$250,000 a year, and
Mhm.
somebody spends 3 years in a nursing home before they pass away, that means that Medicaid will come after you for $750,000.
Uh, well, Medicaid, that's typically the
Potentially.
private pay rate. Medicaid pays at a Medicaid rate. It might be more like, reduce that by a couple of 100,000, but it's still a huge, huge number. You know, it might be instead of 750, 600.
Right.
Still a
A
lot of
lot of
money.
money.
Yes.
Right. So, and we're talking about now irrevocable trust that
It
once
is.
the asset goes into it, you cannot take, you can sell the asset, but the funds don't go to you, they go to the trust.
It stays in the trust, yes. But the thing is, David, I know it sounds counterintuitive, but you can revoke an irrevocable trust. We have a section in the law that says if you follow certain procedures and you get the consent of the creator of the trust, called the grantor, the trustee, and all the beneficiaries, then you could revoke the trust. So over the years, we figure out a way to make even an irrevocable trust fairly easy to revoke and or modify if need be. And the reason I bring this up, because I know a lot of my clients, when I say the word irrevocable, they say, I'm never going to do anything irrevocable. Well, don't worry about it, is my advice.
Now, when is a regular trust, a revocable trust? When is that a good tool?
It's a very good tool. Clients that I just saw this morning, we're doing revocable living trust for them. Uh, they have assets above New York State's estate tax level, which is about 7 million, 7.16 million. And between that and the federal level, and we want to make sure we use trust in this instance to make sure that we use the New York State's exemption, we don't lose it upon the death of a spouse. So we set up a trust for that, and that could be revocable. And we did just did that this morning. Yeah.
Fantastic.
For example. Yeah.
What else should what else should a young person know about trust and estates? You've talked about wills.
Mhm.
You've spoken about a healthcare proxy.
Mhm.
Um, uh, you know, what other things should a young person?
Absolutely.
Yeah.
Absolutely. So just like a healthcare proxy, and again, the healthcare proxy is where you appoint someone else to make your healthcare decisions if you can't make them. Uh, we also have a power of attorney. Power of attorney in New York only involves financial matters. It's where it's a principal agency relationship. It's where the principal, individual, signs a power of attorney and gives the right to someone else to manage their finances. And it's an amazing document. So if an individual becomes incapacitated, someone, again, that you handpick and that you trust will manage your finances and manage your affairs. However, when we do this planning, we don't just use the form of a power of attorney. We expand it. Some of my colleagues call it a sophisticated power of attorney, or an estate planning power of attorney, or an elder law power of attorney. We add many, many provisions to that power of attorney to make sure that we can do estate planning, that we can jockey the assets back and forth, and that includes the home,
Mhm.
uh, so that we can use up the federal exemption for estate taxes, currently almost $14 million. If we can get the discounts, we could do almost anything that that individual could do financially. So in New York State, the power of attorney is only there for financial purposes, and we have a separate healthcare proxy where you appoint someone else to make your decisions if you can't make them. In other states, so if people Google this, they're going to say, "Oh, Ron is wrong. There are powers of attorneys for healthcare decision making." That is correct, but not in New York State.
Right.
Yeah.
Now, the one document we haven't spoken about, and I think it's very important, as we've spoken, my wife is a social worker. She has worked for over in healthcare for almost 40 years.
Mm.
Um, uh, is uh, is the directive, the medical directive, where you actually can say, if I ever have in a hospital whether it be something called a mulst, which is very specific end of life decisions, or more general, you may have very strong opinions about, let's say, do I want to be resuscitated in certain instances? Do I not want to be resuscitated? Whatever. And what, today is the best day for you to make those decisions when you're healthy and when you have the capacity to decide how you want to live and how you want to pass.
Right, exactly, exactly. I know exactly what I want, and I sign those documents. And the document is typically a living will, and the living will sets forth what your healthcare wishes are going forward, and everyone is a little bit different. So you might see forms on the internet, some might apply to you, might be good, maybe not. Uh, I urge individuals, the individuals that might be viewing this, you could do a living will on your own, but don't do a trust, a will, or the powers of attorneys on your own.
So
That
don't go to the internet and
no,
download a will. What
no, there's
risks there?
so many reasons. So many reasons not to do it. Number one, it might not reflect what you want. But there are also issues regarding when that will is signed and the will signing ceremony. And even forgetting all of that, even if the will is just perfect, there's a presumption if an attorney actually drafted that will and supervised it, that the will is good. And it helps later on so much. So the presumption shifts. The presumption is, well, this is a good will because an attorney drafted it and supervised it. So even just for that, but you also get an attorney who's done this a million times and will do it right and make sure that that will fits that individual. And everyone has a different idea on what they want and what they don't want.
Right. That's been great.
Yeah.
What else should we talk about?
Yeah, well, yeah. So we went over the main documents, and I think I should just repeat it. It's the last will and testament, power of attorney that's expanded, the healthcare proxy where you appoint someone else to make your healthcare decisions, the living will. A lot of people mix up a last will and testament with a living will. So last will and testament, where your assets go when you pass away, that excludes assets that have beneficiary designations on them and assets in a living trust. But don't mix up the last will and testament with a living will. Living will sets forth what your healthcare wishes are while you're living. You don't want to be kept alive artificially if there's no chance of recovery, or you do want to be kept alive artificially. I have several clients, believe it or not, signed up for cryogenics. Ted Williams, the baseball player, did that, so that if they find a cure for him, maybe he'll come back. It's not my thing, but anyone could do what they want. And, in certain religions, we have Orthodox Jewish clients, so many, I'm Jewish myself, they might have a halachic living will. And you have the rabbis, or you could even have a priest in certain instances chime in on what the right thing to do is based on your religion. Yeah.
That's
And then
great.
you have a living trust. And that's the document, I think, that brings it all together. Because, the living trust, yes, it avoids probate, but it goes very much more than that. Could also protect assets from Medicaid, reduce or eliminate, in most cases, eliminate the state taxes. But it even goes beyond that. It provides for continuity of management of assets while you're living. So if I have all of my assets in a living trust, and I go in for surgery and I'm in a coma for 3 weeks. Well, I have a successor trustee that I've named. You don't have to even use the power, no court intervention, no nothing. That successor trustee who knows exactly what I want to do, and I have the trust agreement sets forth exactly how the assets are to be managed and what happens, just steps in, takes over, and does what he or she's supposed to do. When I hopefully come back out of this coma, this hypothetical coma, everything is in the same place it was. It was in this trust, and everything is good. If I, God forbid, would have passed away, assets would be distributed without going through probate. It's very, very simple, no muss, no fuss, and it makes things a lot easier. And also, it makes the assets less difficult to contest. So when somebody signs a will, certain family members can contest, and it's an issue sometimes. When you have a trust, family members can contest the trust, but it's much harder to do. So, if there are issues within families, we typically do living trusts.
Hmm.
Yeah.
Makes sense.
And another reason to do a trust, clients often have property in another state, could have a condo in Florida and property in New York. Well, it's bad enough to go through probate in New York, but if you have a condo in Florida, for example, or Arizona or wherever, uh, you would have to go through ancillary probate in Florida. So you're talking about two probates. And I remember that on the first day of T&E, Trust and Estates in law school, my professor said, living trust, and always remember, your client has property in two states, flag goes up, living trust. I remember that. And there are other reasons to have a living trust as well. I'm happy to go over that if you want to know, but
Sure.
sure. Okay. So going beyond the estate planning and the Medicaid planning, let's say you have a child with special needs, and that child is already on Medicaid, already getting SSI, supplemental security income, but you want to give them something. So some clients say, okay, I'm going to give that asset to your sister. She'll take care of you. Well, what if the sister gets ill or passes away before? What if she has a spouse? Don't do that. Set up a special needs trust, also known as a supplemental needs trust, so you could provide a war chest. Let's say you'll put in $500,000 in this special needs trust, which can be in your will. That's the testamentary trust, or it can go into your revocable or even your irrevocable trust, even your Medicaid trust, the MAPT. You could preserve your assets for Medicaid, and for one of your beneficiaries, could be a grandchild or a child, you can have a special needs or supplemental needs trust where the child can stay on benefits, stay on SSI, still get Medicaid for their health care, and then have this war chest there. A child wants to go to a special camp in the summertime, do it. And that child might be 50 years old. It doesn't have to be, underage.
Right.
And we have that all the time. So the money in that trust hopefully will last for the individual's lifetime. And since it's the parents' money, if it's not used and that child passes away, well, everybody's going to pass away, could also go to other family members. And Medicaid does not, we spoke about Medicaid recovery, does not recover against those assets.
Hmm.
So when you have a disabled child, minors trust in all of our trusts and wills. But there's also spendthrift trusts. I get this at least once a week. Client comes in and says, I absolutely adore my daughter. I love her. I trust her, but she can't hold on to money. If I'll give her $100, she'll find a way to spend 200, and it goes on. Said, I want this money to last for her lifetime. So we would set up a spendthrift trust. It's a trust that will dole out the money over a period of time, could be 10 years, or it could be over the child's lifetime. And again, that child could be, 15, or that child could be 50. If there's an issue where you're concerned that that money will be wasted, we could set up a spendthrift trust, and we do that at least once a week.
Mhm.
And you've heard of Leona Helmsley that set up a pet trust, $12 million for her dog, uh, the golden dog, I guess. But we do that a lot. I have a lot of clients that have horses, wealthier clients, and sometimes just very beloved animals. And they
Mm.
want to make sure that there's a home for them. They don't want to sick, that on someone else without funding it. And that's a pet trust that we do as well. So, there are so many reasons to do trust that may not just seem obvious to people listening to this.
So I just want to circle back to part of our conversation where we were talking about irrevocable trust.
Mhm,
And from a mortgage standpoint,
mhm,
it's important to know that I have over the years found one or maybe two lenders in the
mhm.
entire country who would actually do a refinance on a property held in a trust, or maybe do a mortgage acquisition mortgage.
Mhm.
So be careful with putting your house into that kind of a trust. Make sure you've spoken to a really good, like a great elder law attorney like Ron. But it's absolutely critical because a lot of people, do things without understanding fully the ramifications.
Oh,
And
yeah.
so I just a caution there, obviously if someone's in their 70s or 80s, it may be more imperative. Someone younger than that, putting their home into an irrevocable trust, I wouldn't recommend it unless there's some overriding reasons.
Yeah, yeah, absolutely. And there are ways to draft that trust so that it is irrevocable and you're protecting, for example, assets from Medicaid, but for tax purposes, it's in your name. Uh, do I have a couple of minutes to explain
Sure.
or? Oh,
Yeah.
okay. So my typical elder law client might have bought their homes 40 years ago. Uh, and I'm going to get to the mortgage issue as well, but might have bought their homes 40 years ago. They might have a very low tax basis. And if the home is in your name when you pass away or any asset, you might have bought Apple stock at the IPO. I wasn't smart enough to do that. But, you die, the basis gets moved up. If you owned it at the time of death, the basis gets moved up to the market value at death.
So let's give people an example because a lot of people won't know where you're coming from. So let's start with the basics. If you buy a home
Mhm,
and you reside in it as your primary residence,
mhm,
there's the 2 out of 5 rule, which says if it's been your primary residence for at least 2 of the past 5 years,
mhm.
then when you sell, you get a step up in basis of $500,000.
Well, actually, it's
It's
a
it's not a step up, it's a
$250,000 capital gains tax exclusion on a sale.
yeah. So it's 250 per person, 500 for couple. So
Correct.
you bought the house for 250, you were brilliant 20 years ago. Now it's worth $1.5 million. You're not going to pay tax on $1.25 million of gains because the first 500,000, if you're married filing jointly, but the first $500,000 of gains is subject to capital gains exclusion on a primary residence.
Yeah, so that's if the trust sells the property, which is wonderful. So a lot of people don't know that. And it's interesting, the IRS code, it's written in English, these sections, believe it or not. It's section 121A of the code, and they have regulations that go over all of this, and it's very interesting to read. Maybe for me, but I think it's very interesting to read. But that's if the home is sold, even in the trust, the way we draft our trust, it's a completed gift for Medicaid, but an incomplete gift for IRS purposes. And many banks and mortgages would look at this as not a transfer into the trust because for IRS purposes, it's an incomplete gift and there's still some strings there. But that what you described is so important. That 500,000 for a husband and wife capital gains tax exclusion, which is a bit different than a basis step up at death. But even though the home is in that irrevocable trust, you still would get the $500,000 capital gains tax exclusion. And if you die, well, we all will die, even if the home is in the Medicaid Asset Protection Trust, that mapped. If that trust is drafted right, we will get that basis step up, which means if the basis is $200,000 and you die and the home is valued at $2 million, the basis will move up to $2 million at the time of death, and that's going to be your new basis going forward. Well, you're going to be gone, but your family will get that home, your children or whoever.
Yeah, you won't have to sell the house and take a huge hit.
Exactly.
This has been so great. I'm going to ask you to send us your documentation so anyone who wants to talk to you will be able to reach out.
My pleasure.
This has been the Mortgage Made Easy podcast. I'm Dave Steinberg, and we've been blessed to have Ronald Fatula here. Ron is a partner at Meltzer Lippy, a very nice New York firm, and he is the pro when it comes to elder law and trust and estates issues. I strongly recommend that if you have an issue like this, reach out to Ron. Thank you so much. Thanks for your generosity being here, and let's look forward to carrying on this conversation.
Thank you so much, David.